Good morning, good afternoon, good evening from Shanghai. This is Lin Yang from the Hong Kong International Arbitration Center. Welcome everybody to the fourth and also the last session of HKIAC Chinese Arbitration Insights webinar series. The first and the second session were moderated by me, and the third session was moderated by my colleague, Ms. Sarah Grima, Secretary General of Hong Kong IAC. I hope all of you enjoyed the past three sessions. As we have mentioned before, the HKIAC Chinese Arbitration Insights webinar series has been the first ever webinar series launched by HKIAC that specifically targets mainland Chinese arbitration that is relevant to offshore arbitral institutions. In the past sessions, we discussed three topics: foreign-related elements and the governing law and the Chinese laws, the state of arbitration and the foreign arbitration institutions administering arbitration in mainland China, as well as mainland China and the investment arbitration. 6 prominent speakers have joined us, including Helen Shi from Fonda Partners Beijing, May Tai of Herbert Smith Freehills Hong Kong, Ren Feng Ong QC from London, Tao Junzhou of Arbitration Chambers Hong Kong, Cao Lijun of Zhonglun Law from Beijing, and Emanuela Giacomi of Sherman Sterling, Singapore. Today's webinar is about the obtaining interim measures and the enforcement of awards in mainland China. As many of you know that interim measures are crucial in international arbitration. Not only will it facilitate the smooth conduct of arbitral proceedings, but it also safeguards the enforcement of a final award. However, before the interim measures arrangement between mainland China and Hong Kong came into force on 1st October 2019, the legal basis for mainland courts to grant interim measures in support of arbitral proceedings seated outside mainland China was extremely limited. Now, the interim measures arrangement and the 2020 supplementary enforcement arrangement have covered all the stages of arbitration related to Hong Kong arbitration. Under the interim measures arrangement, Hong Kong, as a seat of arbitration, has become the only jurisdiction outside mainland China where parties to arbitral proceedings administered by 6 Hong Kong arbitral institutions would be able to apply for interim measures before the mainland courts. Proudly, HKIAC is the first and the only arbitral institutions to circulate the practice, data, and frequently asked questions on the interim measures arrangement. For sure, the issues regarding the obtaining of interim measures and the enforcement of awards in mainland China are both critical and complex. So I believe our guest speakers today will explain all the importance and the recent developments of obtaining interim measures and the enforcement of arbitral award in mainland China. Today, we are very fortunate to have 2 excellent speakers joining us, Ms. Meg Altpack and Dr. Xiao Kai. Ms. Altpack is the dispute and compliance partner at the King & Wood Mallesons with rich experience in China-related arbitration. I understand Meg had been based in Shanghai for more than 10 years. Right now, Meg is based in New York City, so it's quite an early morning time for Meg. Thank you, Meg. So Meg has been representing Chinese and multinational companies in arbitration, administered under a different set of rules, and also in litigation before US court. Also, Meg is the member of HKIAC Council and the member of HKIAC Appointment Committee. Welcome, Meg.
Thank you. Thank you, Ling, and good morning and good evening to everyone.
Okay, so Dr. Xiao Kai. Dr. Xiao Kai is Vice President of Shanghai Financial Court. So before that, Dr. Xiao was a professor at Shanghai Jiao Tong University Law School, and he served as a prosecutor of Shanghai People's Procuratorate. Dr. Xiao got his doctorate degree from Wuhan University Law School with the major in private international law. Dr. Xiao, welcome.
Thank you, Yang Ling. I'm very glad to be here.
Okay, thank you both, Meg and Dr. Xiao. Thank you both for joining us today. So before we get the event started, I have some housekeeping matters for our audience. So our today's session will have two parts. First, we will have a panel discussion with Meg and Dr. Xiao on 5 group questions. And then the session will be devoted to a 15 minutes Q&A. So, dear audience, if you have any questions related to today's topic, please resort the Zoom's Q&A function just at the bottom of your screen, and we will try to answer your questions later. So now, we would proceed to our first part, panel discussion. As before, I have prepared 5 groups of questions for Meg and Dr. Xiao. So the first question, I would like to ask Meg. Hey, Meg, I understand you are experienced international practitioners in international arbitration. I'm just wondering why parties need to apply interim measures in international arbitration. And could you please introduce how do parties get interim measures in international arbitration generally? Thank you.
Sure. And as I said, good morning, good evening. It's a pleasure to be here. Ling, you know, interim relief in international arbitration is just so crucial to parties, and it's something we all have to consider. And I think everybody who has drafted an arbitration clause has seen arbitration clauses in the past where you had this dispute or anything related or arising under this contract will be subject to arbitration in this particular location and institution and seated in a certain location. And then there was always a supplemental paragraph that said, but if you need interim relief, if you have to go and preserve assets, and we'll talk in a minute about different types of interim relief, but if you have to get interim relief, then you can immediately go to a court in the local jurisdiction and seek where the respondent is and seek to preserve the assets or do whatever you have in terms of injunctive relief or preservation. And the problem that arose under those clauses often was that it created some conflict and some ambiguity about was the arbitral award or was the arbitral enforcement or the arbitral clause, was that enforceable? And was there any ambiguity about when you could go to court or whether it was the exclusive jurisdiction of the arbitrator? So over time, what's happened is institutions have recognized that that was a clumsy system and we needed to have measures for interim relief that allowed for arbitral tribunals to render that type of decision. And then also to allow for recognition of when is it the jurisdiction of the arbitral tribunal and when should I be going to court. And also mechanisms for arbitral tribunals to work with courts to effectively obtain interim measures. So we've seen an evolution of it over time. And I think, you know, the interim measures that we're going to talk about today, you know, really show how important and how easy it's become to protect your interests. You know, when we talk about interim measures in any jurisdiction, we're really talking about 3 types. We want to preserve evidence, right? We, you know, maybe there's a factory where there's certain material that you immediately have to have as evidence, or maybe there's a shareholders agreement or a fraud document or something like that where you need to obtain it. You're going to need to have an interim measure to preserve that evidence so it can be used in court if you know that it's out there. There's obviously preservation of assets. Assets are freezing the other side's bank account or freezing a factory or, you know, real property, etc. And then lastly, preservation of conduct, which is usually what we in the West and common law courts call, you know, enjoining a party's actions. And as everyone knows, I think on the call, you know, there's a difference between an injunction that stops someone from doing something and something that affirmatively forces someone to do something. The latter is very difficult. It's very rare that you're going to get as an interim measure an arbitrator or a judge to say, company X has to transfer shares. You have to complete this deal. but it's quite easy to get interim measures in most jurisdictions. It's fairly easy to get interim measures that say, this company has to stop selling this product until the dispute is resolved, an infringing product, for example. So interim measures are key in all disputes, I think, but if you're dealing, for my purposes, if I have a license agreement, anything related to IP, debtor-creditor situation, loans, often share purchase agreement or equity or asset sales, those types of deals really do have a lot of issues that arise under and require emergent relief. Though in most institutions, we now have emergency arbitrator provisions. You can go in, seek a decision from an emergency arbitrator, and then use that decision to go into a local court and seek enforcement. The challenge that we've had, as you know, in China, we really didn't deem those awards before 2019 to be final awards under the New York Convention. And so we had to think creatively before 2019 about how could we go into a local court in China and come up with a theory against a subsidiary or the company itself that was outside of the arbitration clause. And that was clunky and cumbersome and ineffective, and it really led to a lot of confusion as opposed to successful ways to protect one's interests. So we're going to talk a lot today about how now has that changed with the interim measures. But I think, in terms of how you approach it, obviously your first stop is within your arbitral proceeding, can you get emergent relief? And then the second stop is, do I need to go to a local court, and if so, how? So we're going to talk a lot about that today, but I'll stop there, and I don't want to go in too long.
Yeah, thank you, Meg. So this is a very thorough introduction to the interim measures in international arbitration generally. And I would like to answer the similar question to Dr. Xiao, because Meg just introduced different types of interim measures in different jurisdictions, injunctions, conduct behavior preservation, just like in mainland China. So the question I would like to ask Dr. Xiao is that, what categories of interim measures may mainland court order in support of arbitration? Who, or I should say, which is the competent authority to grant the interim measures in support of arbitration in mainland? And Meg just mentioned a very important time point, 2019, the year of 2019. So my question is that before 2019, can parties to arbitration seated outside mainland China, can the parties apply for the interim measures before PRC court? Thank you, Dr. Xiao.
Thank you, Yang Ling. I should say I'm very glad to be here today to join the webinar on this very interesting topic. As you know, the interim measures is a concept in international arbitration. And according to the Article 17 of the Ancestral Mother Law, the interim measure is a temporary measure which is ordered by the tribunal before the party dispute is resolved by the final word. So such measures may, inter alia, order a party to maintain the status quo pending the final determination of the dispute, or take actions that would prevent harm to the arbitral process itself, and etc. And in the Chinese arbitration law, the interim measures counterpart is preservation measures. There are three categories of preservation or interim measures that Chinese court can order to facilitate the arbitration, namely preservation of assets, evidence, and conduct. The assets and the evidence preservation are stipulated in 1995 China arbitration law, that is Article 28 in 46 and 69. And the conduct preservation is provided in the 2017 PRC civil procedure law, that is Article 100. It is also clearly stated that in the Article 1 of the arrangement that you just mentioned between the mainland China and Hong Kong on the mutual assistance in court order interim measures. In that Article 1, these three categories of preservation measures are also clearly listed. And Mac just mentioned that emergency arbitrators, arbitral tribunals, and Hong Kong court are able to grant interim measures, in contrast to those practiced in other model law jurisdictions. In China, only courts have the authority to grant interim measures in support of arbitration. According to Articles 28, 69, and 46 and 69 of the PRC arbitration law, in order to get the court-ordered interim measures, an applicant should first submit its request to the arbitral tribunal, and then through the arbitration commission to forward the interim measures application to the competent court. Obviously, the 2019 arrangement has changed that practice in the domestic settings. And it's also worth noting that the October the 1st, 2019 is a very important time point. As you may say on the slide, before 2019, the mainland court only granted interim measures in support of mainland arbitration administered by the mainland arbitration institutions. The interim measures available from mainland court in support of arbitration seated outside of mainland China were extremely limited, as Dr. Yang just mentioned earlier. Overall, parties to arbitrations seated outside of mainland China were not allowed to apply for interim measures before mainland courts. The only exception exists in maritime arbitrations. However, for the foreign maritime arbitration outside of mainland China, for example, London or Hong Kong, the preservation of assets could only be applied to vessels or vessel-related assets under Articles 21 or 28 of the PRC Special Maritime Procedure Law. No other kinds of commercial assets could be preserved. For other types of foreign arbitration, parties are not allowed to apply for interim measures of protection before mainland courts. So you can see that a significant change took place 2 years ago on the October the 1st, 2019, when the interim measures arrangement came into effect between the mainland and Hong Kong. After October the 1st, 2019, for the first time, mainland court can grant interim measures in support of Hong Kong seated arbitration administered by 6 specific Hong Kong arbitration institutions, including Hong Kong International Arbitration Center. So you can see there is a great change, and the 2019 is a critical time point.
Yeah, thank you, Dr. Xiao. Thank you, Mac. I believe all the audience have learned a lot from Dr. Xiao and Mac's introduction about the different types of interim measures in different jurisdictions, especially for the jurisdiction for mainland China. The mainland court is the only authority to grant interim measures, and before the arrangement, mainland court only granted interim measures in support of mainland China domestic arbitration institutions. And thank you, Dr. Xiao and Mag. Both of you have mentioned the interim measures arrangement. So as some of you may know that the government of Hong Kong SAR and the SPC, Supreme People's Court of PRC, concluded the interim measures arrangement in April 2019. And very soon after that, HKIAC was recognized as a qualified institution under the arrangement by the SPC and the Department of Justice of Hong Kong SAR. Then the interim measures arrangement came into effect on the first day of October 2019. Since then, HKIAC, we are here, has seen and assisted 47 interim measures applications made by parties to the mainland courts over the year. For those applications, HKIAC has issued letter of acceptance to help parties apply for 23 different mainland intermediate courts in 19 mainland cities. So among those applications, 44 applications were made for the preservation of assets. The total value of assets preserved by decisions rendered by many courts amounted to $1.7 billion. Parties, another interesting observation on the interim measure arrangement. Parties in those applications also show great diversity in their nationalities. Precisely, applicants are split about 24% mainland Chinese against 76% foreign parties. Respondents are split approximately 55% mainland Chinese against 45 foreign parties. So it is worth noting that HKIAC has published frequently asked questions about the interim measures arrangement in 5 languages: English, Chinese, Korean, Russian, and Japanese. So if our audience of today wants to get more information about the interim measures arrangement and especially the experience HKIAC has gained over the last 2 years, please visit the HKIAC website. So next question. So I would ask Meg first. Okay, so Meg, as an international practitioner, what significance do you think the interim measures arrangement carries in international arbitration?
Well, it's a very important question, and I think I'm going to start with the fundamentals of being a practitioner. And so, as a lawyer advising clients and as a general counsel within a company, I think one of the first things you have to ask yourself is, if I bring this arbitration and I spend all this money on the lawyers to get an arbitral award, am I going to be able to enforce it? By the time I go to enforce it, will it have any meaning? Because if I can't preserve assets, if I can't get the evidence I need, if I can't make sure that, there isn't a fraudulent conveyance of, assets, or there isn't a destruction of evidence, then that's going to ruin my case. And so if I don't have a case, I shouldn't be spending a lot of money on an award that I'll never be able to enforce. So I think for practitioners, you can't understate really the importance of the interim measures arrangement as it relates to the PRC. Now, there's a bit of a confusion, I think, sometimes, because people will think in their mind, oh, this is really for foreign parties chasing Chinese companies. And what we've seen, and you just cited some of the statistics, like, what we're actually seeing is a lot of Chinese parties taking advantage of the interim measures as well. So the idea that this is just a sword for foreign parties is really inaccurate, to be frank. But I think one of the things that surprised me, because as you know, I was based in Shanghai and then London, and now I'm between New York and Shanghai. And what shocks me is the extent to which practitioners really don't understand the interim measures, don't know about the interim measures, and don't consider that when they're preparing and drafting arbitration clauses. And so in my view, and I don't want to be too harsh about this, but it's, when I talk to, some lawyers in New York who are drafting IP license agreements, for example, and they say, well, I don't want to use Hong Kong because, are there issues in Hong Kong? And I say to them, well, if you don't use Hong Kong, how are you going to stop infringement? How are you going to preserve assets? And they say, well, what do you mean, right? I can do ICC Paris. And I say, no, you can't. You're not going to be able to protect your client. So the lack of information, and it's really dangerous, actually, that people are not aware of the implications of not choosing a Hong Kong seat for disputes where they're going to have to exercise their rights on an urgent basis. And they have to protect their client. And so it's a shame, but you often see clauses that when I look at them, I think that's not going to do you any good. You're not going to, at the end of the day, client, you're not going to be able to enforce that award, or you're not going to be able to get the emergent relief that you need to protect your interests. So I think for me, the IMA, when it comes to international arbitration, is it first off, as I said, it runs both ways. Chinese parties should take advantage of it as well, and they do. But then I think the second piece is, if you're not thinking about Hong Kong as a seat, then you're really not doing your job. And I don't mean to, I know that sounds very harsh, but I think that, we need to get the word out that this is a crucial tool, and you have to look at it. You have to consider it when you're drafting your clause and when you're talking to a client about whether they're going to spend $1 million to chase an arbitration award.
Thank you, Meg. So very interesting comments on that. So I should say that you pointed out a very critical practice under the interim measures. So interim measures arrangement is an equal tool for both mainland Chinese parties and the foreign parties. I have seen that from our case statistics. Yes, that was true. And a similar question to Dr. Xiao Kai. So Dr. Xiao, I understand some mainland Chinese judges believes that the interim measures arrangement reflects the mainland judiciary support of offshore, especially Hong Kong arbitration. Do you have any comments on the statement and the interim measures arrangement?
Before I answer the question, I would say that Meg's comments on the importance of the 2019 arrangements is a very fair comment. So, and also established this is a very important legal assistance, mutual assistance between the mainland and Hong Kong, and established Hong Kong as a primary arbitration center internationally. And I'll turn to your question, the mainland judiciary attitude towards the arbitration. Actually, arbitration is a widely recognized and respected process for commercial dispute resolution. And the mainland judiciary has been committed to facilitating alternative dispute resolution mechanisms and supporting arbitration especially. As you know, that China has been a signatory of the New York Convention since 1985, and always strictly fulfilling its obligations to support arbitration under the convention. Under the guidance of the Supreme People's Court, the mainland China judiciary has taken a pro-arbitration approach consistently over the years. For example, the Supreme People's Court issued a judicial interpretation in 1995, establishing what we call a prior reporting system concerning the enforcement of awards of foreign-related arbitral awards. The so-called prior reporting system is the feature of judicial review of arbitral awards that has the strongest Chinese characteristic. In China, only intermediary court has the jurisdiction to review arbitral awards. Under this prior reporting system, any judicial decision of intermediary mainland court to refuse recognition or enforcement of arbitral award, no matter domestic or foreign arbitral award, has to be reviewed by the higher People's Court, which is at the provincial level, and then later by the Supreme People's Court. That is to say, any refusal judgment should be requested by a local court and be approved eventually by the Supreme Court. So the Supreme People's Court has the final say upon non-recognition or non-enforcement of arbitral awards. This is a procedural mechanism, functions as a safeguard to ensure effective arbitral awards enforcement in the Chinese court. So over the past 26 years, the prior reporting system has played an essential role in safeguarding the recognition and enforcement of arbitration awards, including Hong Kong arbitration awards. Therefore, generally speaking, the mainland judiciary has been very supportive of arbitrations. For sure, the interim measures arrangement has been a milestone in the history of the mutual judicial assistance between mainland and Hong Kong. It is also the only arrangement regarding interim measures in aid of arbitrations that mainland China has signed with other jurisdictions. The mechanism derived from the arrangement is unique worldwide. In this sense, the interim measures arrangement further demonstrates the mainland's supportive attitude towards arbitration. It facilitates arbitration to play an important role among multiple dispute resolution mechanisms and provides great support to the development of Hong Kong as an international hub of dispute resolution in the Asia-Pacific region. Lastly, just as Dr. Yang and Meg has said, the interim measures arrangement is indeed a great innovation achieved by the mainland China and Hong Kong to support arbitration. As you may have known, the interim measures arrangement, along with the 2020 supplementary enforcement arrangement, have covered the whole process of arbitration-related interim measures applications. It has made Hong Kong a unique arbitration seat with the benefits of ancestral model law and interim measures available from the mainland court. But also the arrangement had made mainland China a more open, international, and arbitration-friendly jurisdiction in terms of legislation and judicial practices.
Thank you, Dr. Xiao. So let's move to the third questions. I mean, the third group questions. So I want to move the question more specific or technical. So Dr. Xiao, I would like to ask you first. I learned that the Shanghai Financial Court had experience in handling interim measures application and the interim measures arrangement. So could you please introduce how to apply interim measures before mainland court under the interim measures arrangement? So for example, what kind of documents or evidence or materials that the party need to submit, and could the parties apply for interim measures to the mainland court directly, or must submit all the applications through Hong Kong IAC, or how long it will take for mainland court to decide on such applications? Thank you.
Well, this is a very good question. I suppose most of our audience may not be so familiar with the mainland judiciary and our practice. I would like to take this opportunity to introduce how to apply for interim measures to a mainland court. Last year, the Shanghai Financial Court, where I serve, had the chance to handle a case under the arrangement. The arbitration was administered by the Hong Kong IAC, and the amount of asset preserved was about 370 million US dollars. I will use this case as an example to illustrate how the mainland court generally deal with the interim measures application. The first, can the parties apply interim measures to the mainland court directly? The short answer is yes. Let's take a look at the interim measures arrangement first. Article 3, paragraph 2 of the arrangement stipulates that the application shall be submitted to the competent mainland court through the arbitral institution or permanent office in Hong Kong. However, given the arbitration institutions or permanent office are located in Hong Kong, if every application is required to be submitted to the mainland court through the transfer of the Hong Kong arbitral institution or permanent office, the process would be very time-consuming. For this reason, the Shanghai Financial Court accepted the documents submitted directly by the party in this case. Besides, under Article 4 of the arrangements, an applicant applying to the mainland court for interim measures shall submit a letter from the relevant arbitration institution certifying that the institution's acceptance of the relevant arbitration case. The Hong Kong International Arbitration Center just did so in this case, and is noteworthy that although the letter are produced in Hong Kong, notarization and certification are not required. Specifically, in my case, the applicant is a Switzerland company, first submitted its application form to our court through the transfer of the Hong Kong IAC. Considering that the applicant had hired attorneys in mainland, and it was more convenient for the applicant to submit materials directly to my court, we later allowed the applicant to submit supplementary materials directly to our court. This practice complies with the Supreme People's Court interpretations and application of the arrangements that parties to the Hong Kong arbitration should be allowed to submit the application directly to the mainland courts. So as to this sub-question, parties are allowed to submit the application directly to my court or through the transfer of the arbitration institutions or permanent office. If the application is directly submitted, our court may verify some information with the arbitration institution or permanent office when necessary. The second sub-question is about how does our court review the application documents and materials. Basically, the requirements of those application documents are listed in the Article 4 of the Interim Measures Arrangement. I will very briefly touch upon those documents required by the mainland court when it comes to the preservation measures. So firstly, you need to submit the application for the interim measures. That is to say, you need to file the application in the format that Supreme People's Court had released the several templates for the references. But also, I should note that this is just the format. We also look at the substance of the application. And then the second is the arbitration agreement. When dealing with the interim measures applications, it is not the case for us to determine the validity of the arbitration agreement, but instead the arbitration agreement will be reviewed upon prima facie standard. And the third document is the documents of identity. So if the applicant is a foreign individual or company, the identity documents shall be notarized or certified together with the Chinese translation. And the fourth documents will be the application for the arbitration and the letter of acceptance issued by the arbitration institution or the permanent office. And also any other documents that are required by the mainland court given the specific circumstances of the application will be also very helpful in the determination of the grant of interim measures. For the case I handled last year, the information or materials needed for granting interim measures are those considerations or circumstances of the case that we need to balance when giving the protection of the preservation measures. For example, you need to submit to the court the basic information of the parties, the details of the application, including the amount of the assets or details of the conduct to be preserved, and the facts, reasons, and relevant evidence on which the application is based, including the explanation of the emergency of the circumstances, so that if the interim measures is not taken immediately, the legitimate rights or interest of the applicant may suffer irreparable harm, or enforcement of arbitral award may be very difficult. This is to facilitate the review of the necessity of the interim measures applied, and also clear information and a specific clue of the assets and the evidence. This is to help the court to enforce the interim measures, and also the information regarding the mainland assets to be provided as a security or certificate of creditworthiness. In most circumstances, the applicants shall provide security. The amount is decided upon whether the applicant's application is before or after arbitration, the type of preservation, the potential loss the respondents may suffer, and the other relevant matters under the civil procedure law and the judicial interpretation by the Supreme Court. And also whether a application has been made to any other court, arbitration institution, or permanent office under the arrangements and the status of such application. So all these information are needed by the court before the final grant of the interim measures. As to the last sub-question, how long will it take to decide on an application of preservation measures? As required by the arrangement, the mainland court shall review the application expeditiously once the application is received. For example, the PRC court should decide on the application for pre-arbitration interim measures within 48 hours once the application materials are complete. However, a time limit is not set for the reviewing and interim measures application after commencement of arbitration. Considering the emergency of preservation, our court will review the application as soon as possible after receiving all the necessary information. For an application after commencement of arbitration, a decision will be made within 5 days from the receipt of all the application materials. If a security is required, a decision will be made within 5 days after security is provided. For example, in the previous case I mentioned, we rendered the decision the next day after the application submitted all the application materials and the security. Our court also specified that the date when the application was received, the materials were complete, and the security was provided in the written decision, so that the court review process is more transparent to the parties.
Okay, thank you, Dr. Xiao. Very detailed introduction to the application, how to apply for interim measures before mainland court. But for our today's audience, I understand most of them came from outside mainland China. So I should say, if you want to apply for interim measures before mainland court, you must work with PRC lawyers. So, and a very important point I want to highlight from Dr. Xiao's introduction is about the timing. That you can see that on these slides that when the parties provided security, only 1 day after that, the Shanghai Financial Court granted orders for interim measures. So very quick for mainland court. So the similar question I would like to ask Meg. So Meg, I understand that you have a rich experience in handling interim measures before courts and tribunals. So from your experience, what is the key applicable standards for mainland court to grant interim measures? Is the mainland court's standard different from the Hong Kong court or Hong Kong IAC's tribunal practice or other model law practices, model law jurisdiction practices?
So, Ling, I have to highlight something you just said, which is obviously I'm a foreigner. So I have the good fortune to work in one of the largest PRC firms that's an Asian-based international firm, King & Wood Mallesons. And so it really is my colleagues in Shanghai and Beijing who do all the hard work and who actually practice in China. And I'm very fortunate to have their wisdom when it comes to these issues. We have done several applications. I can say that the applications have gone very smoothly. HKIAC has been really helpful to us, as I understand it, from my colleagues, whether it's, sometimes the court will require that the letter from HKIAC be sent directly. Sometimes HKIAC will work with us and provide us the letter, and then we'll do the filing with the court. It's a bit bespoke, depending upon where you are, Beijing versus Shanghai versus Guangzhou, et cetera. But on the whole, what we're seeing is you're getting the relief in less than a month. I think the main difference between China and Hong Kong, for example, is somewhat procedural versus substance. So in China, I think for us, the main thing in the filing is, can you identify where the assets are? Because most of these are preservation of assets. And then the second issue is filing the security, because that's a bit unique in China, and you may not have that in other jurisdictions. And I think in that sense, the Chinese courts seem to take a fairly procedural or more procedural approach to, have you done everything you need to do to satisfy the requirement? And then on top of that, is this something that is going to cause, if the relief isn't granted, will it cause irreparable harm to the interests of the party? And is there some emergency, for example, that, evidence or assets will be extinguished before the relief can be granted at the end of, or that you couldn't obtain that future relief? So that's the general standards. And I think Dr. Shao set out very clearly what the standard is that the courts are applying. When it comes to Hong Kong, as you're well aware, the Hong Kong arbitration ordinance really looks at, is there harm that's going to occur that it can't adequately be compensated by damages? I think that's the first key point. And is the harm that's experienced by the party seeking interim relief, is that greater than the harm that might be incurred by the party that is, on the other side? And then finally, the Hong Kong arbitration ordinance also looks at the likelihood of success on the merits. So they go a little bit deeper probably into, whereas they don't decide the merits of the case and they do look at it from a prima facie perspective, they are certainly looking at, is this a good case for the plaintiff and is there a likelihood of success? The HKIAC rules for purposes of emergency arbitrator basically adopt the same standard as the Hong Kong arbitration ordinance section 36. And so there's not a lot of difference there. There's a bit, if you look at the HKIAC rules, I think it's article 23.4, gives a bit more discretion to an emergency arbitrator to look at some other factors if they're pertinent to the immediate issue of do I have the authority and what type of relief can I award and whether or not it's warranted in this particular case. So generally speaking, I think what you see, the difference in the standard really is a function of a civil law country versus a common law country. And so common law countries tend to be more merits oriented and irreparable harm focused. And I think in China, there's also this additional key element of process and procedure, and have you met the requirements? And most importantly, have you posted security?
Yeah, Meg, I totally agree with you. So actually, several weeks ago, for the second week of July, I posted an article about the different applicable standards on granting interim measures between mainland China and Hong Kong on the Clover arbitration review. So I share the similar views you just mentioned. Thank you so much. So we have talked a lot about the interim measure arrangement. Before we move to the fourth question about the enforcement arrangement between mainland China, I would encourage all the audience to ask questions related to today's topic. So you can use the Q&A function at the bottom of your screen on the Zoom. So you can ask any questions related to today's topic. We will answer your questions later. So let's move to the fourth group of questions about the enforcement. So actually, interim measures is the preparation for the enforcement of arbitral award. As to the enforcement of award in mainland China and Hong Kong, the 2000 enforcement arrangement and the 2020 supplementary enforcement arrangement constitute the legal basis where the New York Convention still applies when the enforcement of a foreign award was sought in mainland China and Hong Kong. And over the past 20 years, we are glad to see that HKIAC's awards keep the star records in terms of enforcement in mainland China. So I would like to ask Dr. Xiaokai first for this question. So could you please introduce the 2020 supplementary enforcement arrangement between mainland China and Hong Kong? How does mainland court enforce Hong Kong arbitral award and the enforcement arrangement? Thank you.
Thank you, Yang Ling. As you just mentioned, that the enforcement arrangement between the mainland China and Hong Kong was signed on July 1919 and came into effect on February 1st, 2000. So it has been enforced for 20 years, and the cooperation has delivered fruitful results, I should say. And last year, the supplementary arrangement also was signed, and it contains several in my personal view, very important amendments. There is no doubt that the supplementary enforcement arrangement will further refine the enforcement arrangement in four aspects. Firstly, I would say that supplementary arrangement expressly includes the term recognition when referring to the enforcement of arbitral awards in the enforcement arrangement for a greater certainty. So the procedures for enforcing arbitral awards under enforcement arrangement 1919 shall be interpreted as including the procedures for recognizing and enforcing the arbitral awards of the mainland or the Hong Kong SAR. And secondly, the supplementary arrangement aligns the definition of the scope of arbitral awards with the prevalent international approach of the seat of arbitration under New York Convention. So after the amendment, the enforcement arrangement applies to arbitral awards rendered on the Hong Kong Arbitration Ordinance as enforced by the mainland court, and the arbitral awards rendered on the PRC arbitration law as enforced by the Hong Kong courts. And thirdly, the supplementary arrangement allows parties to make simultaneous application to both the mainland and Hong Kong courts to enforce arbitral awards. This was not feasible before the supplementary arrangement came into effect. Now, if a respondent is domiciled in both the mainland and Hong Kong, or has a property which may be subject to enforcement on both sides, the applicant may file applications for enforcement with the courts of two places, respectively. The only limit is the total amount to be recovered from the enforcing the arbitral award in the course of the two places must not exceed the amount determined in the arbitral award. And finally, the supplementary arrangement address an express provision, add an express provision to clarify that the party may apply for interim measures before or after the court's acceptance of the application to enforce an arbitral award for a greater certainty. So this is also fills in the gap left by the interim measures arrangement 2 years ago. And after insurance of a final arbitral award, a party can rely on the supplementary arrangement and apply for interim measures. So the enforcement arrangement provides a solid legal basis for the mainland court to recognize and enforce Hong Kong arbitral award. And in practice, the mainland courts will strictly interpret the conditions for not enforcing arbitral awards, including arbitrability, public policy, etc.
Okay, thank you, Dr. Xiao. So combined with the slides on your screen, you may understand the whole story, the whole picture about the enforcement arrangement between mainland China and Hong Kong. Before I ask Meg for the similar question, I should say I must answer a question from one of our audience. Mr. Lafa Jaffa, if I was correct, he asked, Lin Yang, what is preservation? So I should emphasize again, as Meg and Dr. Xiao mentioned at the very beginning of this webinar, interim measures is used in international arbitration and the unswitched model law jurisdictions generally. And the counterpart concept in mainland China is preservation. So to easily understand the concept of preservation, you can use the term as interim measures. Okay, so let's move to the question to Meg. Hey, Meg, Dr. Xiao just introduced the developments about the supplementary enforcement arrangement. So do you have any comments on that supplementary enforcement arrangement? So in practice, are there any differences between enforcing the arbitral award and the enforcement arrangement and the New York Convention in mainland?
As Dr. Xiao just outlined, really the enforcement arrangement between Hong Kong and mainland China and then the supplemental arrangement really did adopt the New York Convention in large measure. So there's really, there's not so much any difference. It was a gap filling measure in a way to recognize that Hong Kong, had rejoined mainland China, and therefore, how are we going to handle enforcement of awards from Hong Kong? And so the New York Convention, I think it's worth restating what the New York Convention premises are under Article 5. So Article 5 has two clauses, as Dr. Shao alluded to a bit, that set forth the bases for refusal. And just to remind everybody on the call, so the first is, is there an invalid, or was there an invalid agreement or an invalid arbitration agreement such that, it should not have gone to arbitration at all? So validity of the agreement. Was there lack of notice of the appointment of an arbitrator, or lack of notice of the arbitral proceedings? Did the arbitral proceedings and the award itself, does it go beyond the scope of the arbitral clause? D of Article 5.1d is whether there was some composition or impropriety in terms of the composition of the tribunal, or whether the procedure was contrary to the agreement or contrary to law. And then under 5.1 again, you have, was the award itself, is it not yet binding, or has it been set aside somewhere? Article 5, Section 2 goes to what Dr. Shao was just mentioning, which is a broader sort of a broader and local jurisdiction issue, which the first is, does the subject matter, is it capable of arbitration? So I can give you an example. We had a case years ago where one of the matters submitted to arbitration was whether a trademark right existed in mainland China. And of course, the right itself, you can have a license agreement, you can have breach of a license agreement, but who owns the right is really within the jurisdiction of the court. So that would be an example potentially of a case that isn't so-called arbitrable. And then the other point that Dr. Shao just mentioned was, is it against public policy? And I think it's worth noting, we've done surveys over the years of enforcement in China. The rate of enforcement is actually surprisingly high, and I would encourage people to look at the data and see, in fact, that it is more the rule that it's enforced than not enforced, and that's across the country, not just in Beijing, Shanghai, Guangzhou. And then I would say that in terms of the enforcement itself, obviously now you have the availability of preservation of assets and so forth, that and the assistance of the court to get, the actual, not just recognition, but enforcement. And I think one of the key features of the supplemental agreement was that it highlighted that this isn't just enforcement, it added the language of recognition of the New York Convention. And so it's, I think now we're pretty much on all fours. I would also add that the final Article 5 issue, there was some difference or ambiguity originally about what is public policy versus public interest, I think. And now I think that's, as Dr. Shao used the term policy, I think that is fairly standardized. The only issue I would say is it's very rare actually in PRC courts for an arbitral award to be rejected on the basis of public policy. So in a lot of jurisdictions where you don't have a strong judiciary, public policy is sort of a catch-all for deciding arbitrarily not to enforce an award. And we actually don't see that very often in China. It just doesn't, the statistics show that it doesn't really happen.
Yes, you are right, Meg. Thank you so much. So I understand that one of our audience asked a similar question, asked our speakers to introduce the public policy in mainland court. I don't think we have enough time to illustrate how PRC court or SPC to define public policy, but we may consider this topic for our next webinar series about the Chinese arbitration. Okay, so let's move to the last question. This is the same questions for both Dr. Shao and Meg. So what do you think is the prospect of interim mass arrangement and the enforcement arrangement? Do you expect to see more similar arrangements signed by the mainland China and other foreign jurisdictions? So what do you think Hong Kong as a seat in the international dispute resolution as a hub in the near future? Thank you. So who want to go first? Meg or Dr. Shao?
Well, okay. Meg, please.
Sure. I think I said it emphatically earlier, but I'll say it again. I think for me, the interim measures and the importance of the interim measures as it relates to Asia-related disputes can't be underscored enough. I mean, the bottom line is that it was as we kept saying at the time, it was a game changer. It really does allow parties to protect their interests, and it's quick, it's easy. It's, you can go in and within 3 weeks, less than a month, you can obtain the relief that you need to secure for your client, the confidence that they're going to have a judgment that's enforceable. And that really can't be understated. So from my perspective, it really was a game changer. And I think that, parties, practitioners need to understand it. They need to avail themselves of it. And particularly for corporate lawyers who may not be listening in today, go back and tell them they need to look at this when they're drafting their arbitration clause, because if you think, no disrespect, AAA New York or ICC Paris is going to get you interim relief that you need in China, it's not going to work. And so I'm sorry to be so harsh, but that's my view. I can't emphasize enough the importance of it.
I totally agree with what Meg just said. I would just to add that China domestic judiciary is very supportive of arbitration, and we have the prior reporting system. So as Meg just mentioned, that the recognition and enforcement rate of foreign arbitral award is relatively very high. I just read a article on the statistical report on the recognition and enforcement of foreign arbitral awards in China. If my memory is right, it's about 70% that foreign arbitral awards will be recognized or enforced by the Chinese domestic courts. So with the interim measures arrangements, especially in the business that has something to do with the mainland China, it's very important to have your arbitration seat in Hong Kong. And these interim measures arrangements, I would say, will strongly support Hong Kong's enduring status as an international commercial dispute resolution center. So I will be very confident of the future of the Hong Kong IAC's position. And also, this interim measure arrangement opens the door to other international arbitration institutions. They have their permanent office in Hong Kong. So for those cases, they handled in Hong Kong will be used. Can also apply the interim measure arrangements between the mainland and Hong Kong and get enforced by the domestic Chinese courts. So that's my brief comment.
Thank you, Dr. Shaw and Meg. That is very encouraging. So for those who don't have a rep office or managing office in Hong Kong, you can go tomorrow to set up an office in Hong Kong and take advantage of the interim measure arrangement and enforcement arrangement to get the successful enforcement in mainland China. So that's good. So let's move to the Q&A session. So we have got many interesting questions from the audience today. Many interesting questions. So please, Dr. Shaw and Meg, so please choose, maybe each of you can choose 2 of them you would like to ask, your answer. Let me know. Before that, I would like to answer the first question from Sun, from Mr. Sun. Mr. Sun is the first person to raise the question for this webinar. He asked, how about foreign arbitration institution administered cases taking place in mainland China? Can the Chinese court offer interim measures? Thanks. So my short answer is that, hey, Mr. Sun, please visit HKIAC's website. We have a video visual library. We have discussed this question in all details for our second webinar of this webinar series. So this is not answer to say yes or no. Please to watch the recording of our second webinar. Okay. So for Mac, so which question you would like to answer? Maybe second one. Do you have a model arbitration clause for IP agreements using Hong Kong as a seat, including capacity to seek interim measures? The second one from Armenia. Sure. Yeah, please.
Sure. Amelia, I was just looking through all the various questions, and thank you for everybody's interest. In terms of IP dispute resolution clauses, I think your first starting point is to go on the HKIAC website and look at the model clause. And then, you know, if you're currently drafting the clause, you automatically have access to the interim measures by virtue of the arrangement that is in place. So you don't have to specifically call out interim measures in your arbitration clause. You may want to consider things, obviously you want to indicate that the seat of the arbitration is Hong Kong, that it is a Hong Kong arbitral institution that you're using in the clause. You may want to consider things such as, because I'm on the appointments committee, and one of the things we often look at for IP disputes is the experience of the arbitrators in intellectual property. You may want to consider whether or not you want to insist that, you know, the arbitrators have certain IP experience. But in terms of availing yourself to the emergency arbitrator proceedings or the interim measures, both of those are automatically in place when you select the HKIAC rules, and the language of the clause will say HKIAC rules then in place, et cetera, et cetera. So go on the HKIAC website, go from there. And if you have any questions, give me a call.
Okay, thank you. Dr. Xiao.
There's a question from Alex Ye. In practice, what kind of security would be sufficient for the mainland courts to what kind of security to provide in order to get the interim measures protection from a Chinese court? I guess the fundamental standard is that the security should be provided, and also the amount of the security should be in line with the dispute dispute amount. So, for example, in my case, the claimant would like to preserve the assets worthy of several million US dollars, and in these cases, we would ask the applicant to provide the letter of security from the bank worthy of the same amount of the worthiness. So the amount of the security is sometimes a precondition for the Chinese court to grant interim measures. If there is no security provided, and then there will be no relief for the respondent that might be suffer in the subsequent proceedings.
Okay, good. Thank you. So, Meg, so which question you would like to answer?
There are a couple of questions. I see Andrew Pullen has a question, and there are some others who have asked about the nature of the relief and what's common, and Chinese parties versus foreign parties, what types of relief they seek. I would say across the board, the majority of the applications, and Ling, you have the data, but the majority of the applications are for asset preservation. And really that's seizing bank accounts, making sure the money's there later on, or the factory or the land use rights, et cetera. So I think the vast majority are, regardless of whether it's a foreign party that's applying or a Chinese party, those are the vast majority. I think we're all agreed evidence preservation is probably the next easiest. And joining conduct is difficult in almost all jurisdictions, not unique to China, because, you know, an injunction can be very hard to enforce. You know, the judge can't go out and stop someone from, you know, making a product. I mean, obviously, you put the injunction in place. There are penalties for the failure to comply with the injunction. But the bottom line is, I think, in order of ease, certainly asset preservation and evidence preservation can be easier than injunctive relief. But make no mistake about it, and Dr. Shao, maybe you can speak to this, but certainly there is an opportunity to get injunctive relief in certain cases. So I would say that all three types are available, and that I would say the vast majority are asset preservation, and that the types of relief sought aren't unique to Chinese versus foreign parties.
Okay, good. Thank you, Meg. So due to the time interest, I will ask Dr. Shao to answer last questions. Ask last question you would like to answer. So choose one of them.
I have a very interesting question from Yu Yan, and he asked what documents need to be legalized to be submitted to the court, and if the arbitration is adjourned, well, the property preservation be released. Well, the Supreme People's Court basically provides the templates for all those documents and materials to be submitted to the Chinese court in order to get the interim measures. So you can check on the Supreme People's Court website to get the guidance as to the documents formalities. And the second question, if the arbitration is adjourned, will the property preservation be released? Well, there is also one of my questions concerning the interim measure arrangement is that when the preservation is granted by the Chinese court, we will notify the arbitration commission or institutions in Hong Kong, but there is no specific article or provision in that arrangement as to when the arbitration is concluded, and what will be the responsibility of the arbitration institution to notify the Chinese court in terms of the preservation should be released or not. So if there is a improvement or amendment to the interim measures arrangement, I think we need to specify the time limits of the preservation measures granted by the Chinese court. So, for example, if the arbitration is concluded, if the arbitration is dropped, and then the Chinese court should have the access to this information as soon as possible. And also, obviously, the respondent has the interest to report to the Chinese court because its own interest is at stake. So I guess that Chinese court will evaluate on the process of the arbitration itself. Thank you.
Thank you, Dr. Shao and Meg. Before we conclude today's webinar, as our previous practice, I would give some key takeaways to our today's audience. The first one is, if the transnational transactions involve China-related interests, for example, assets located in mainland China, the parties should consider the interim measures arrangement and the supplemental enforcement arrangement when drafting arbitration clause. Second, combined with the Hong Kong Arbitration Ordinance, HKIAC Administration Arbitration Rules, and the interim measures arrangement, parties to HKIAC arbitrations has several ways and unique way to get the interim measures before Hong Kong Court, Emergency Arbitrator, Tribunal, and mainland courts. Third, thanks to the 2020 supplementary enforcement arrangement, parties to Hong Kong City arbitration can apply for interim measures to Mainland Court after awards was rendered. Combined with the interim measures arrangement, parties to Hong Kong City arbitration can get the interim measures before Mainland courts during the whole stage of arbitral proceedings, namely before the commencement of arbitration, during the arbitral proceeding, and after the award be rendered. Fourth, under the 2020 supplementary enforcement arrangement, parties to Hong Kong City arbitration can apply for enforcement of awards to both Hong Kong and the Mainland courts at the same time. Lastly, we learned today that Mainland judge or Mainland courts are inclined to take a proactive and prudent approach towards application of interim measures and enforcement. So according to the statistics of HKIAC, applications under such arrangements are typically granted with high efficiency by Mainland courts. Therefore, working together with Mainland lawyer, there is a very effective way to conduct China interest-related arbitrations under those arbitration-related arrangements. So conclusion. So today, last but not least, the video of this recording of all our 4 sessions of this webinar series will be soon uploaded to the visual library of HKIAC website. So you may find all the HKIAC's interviews, lectures, webinars there. Also, you could review the videos on HKIAC YouTube account. And if you are based in Mainland China, you also can get all the videos on HKIAC 腾讯视频. So let's conclude today's webinar, the last session of HKIAC Chinese Arbitration Insights webinar series. If our audience have any interest for other topics about HKIAC or China arbitration, please let us know. We may to design another series for you. So thank you, Meg.
Thank you, Yangling.
And thank you, Dr.
panelists.
Xiao.
Thank you, everyone who participated.
Thank you, Yang Li. Thank you, Meg.
Thank you all of you, all the audience for participating for today's event. See you next time. Bye-bye.
Bye-bye.
Bye.